Lawyers, has there ever been a time the opposing counsel accidentally proved your case for you, and what happened? Story 1. My dad's ex-girlfriend took us to court over his estate after he kicked her out. Her claim was that she was entitled to half the pie due to de facto marriage. Our claim was that she was a gold-digging whore who planned it from the beginning. She had mountains of evidence of her contribution to Dad's company and running the private estate. Expense reports, receipts, dates, and times her and Dad proved their relationship, with trips and combined spending, etc., etc. She had so much evidence, the judge took 4 days to look it all over, after which he came back and basically said, "Why the hell would you have all of this if this wasn't your plan the whole time?" The case was very downhill from there. Edit, Jesus Christ weepin' bell. Okay, some more clarification. 1. She'd done the same thing to her ex-husband, giving precedent. He and her children said so in their testimonies. One of her children even inadvertently admitted she'd told them what to say and paid them for it. 2. We were able to name the date the relationship between her and Dad ended, which was months before she claimed, and outside the time limit to make it a de facto/common law marriage. 3. We had testimony from the doctor at his ICU, who said she tried to keep everyone, including his ex-wife, our mother, and us, his children, away from him. Meanwhile, she had his phone and computer, and was trying to take over his contacts and business. We had proof of this. 4. Her lawyer was a moron, who constantly contradicted himself and the evidence. He lost documents, gave incorrect dates, and asked irrelevant questions of the defense. 5. In the end, it was that her expenses for the relationship were deemed normal for anyone in any kind of romantic relationship, that gifts and meals aren't claimable for compensation, that her contributions to the household and business were not sufficient to warrant compensation. She never actually put any money into either, and that the relationship was not sufficient in duration to qualify as a common law marriage. 6. This case took 4 fucking years to settle, including 2 elevations of appeals. She finally gave up because she'd run into about $250,000 of court fee debt, as well as being forced to pay us $40,000. Story 2. I had a misdemeanor possession case I was defending. Client was driving his mom's car. He gets pulled over for playing the stereo too loud. There are pills in the center console, in a prescription pill bottle. The bottle has his mom's name on it. Client gets arrested and charged with possession of a controlled substance without a prescription. Case is obviously bullshit, but the dumbest DA I've ever met in my life won't dismiss. We go to trial. During closing arguments, the DA says, "This case is a circumstantial evidence case." During my closing, I slap the jury instruction on the projector that says, if a case is based on circumstantial evidence, and there is one factual scenario that points to guilt, and one that points to innocence, the jury must find in favor of the defendant and acquit. My client was acquitted. Edit. RIP my inbox. Also, there are some amazing discussions below. That makes me really happy. I responded to as many questions as I had time for. DM me if you have a legal question about this case. Lots of you were interested, so the jury instruction is Calcrum 224 if you want to look it up. Story 3. Not a lawyer, but was taken to court once. A guy had taken my family to court, basically he had been dating my mother, and things ended. So he then takes us to small claims court, with an itemized list of everything he'd ever bought the entire family. Every cheeseburger, every Kit Kat. He even billed for things he did, like house repairs. Some of the repairs were terrible, and ruined other things. He tried to unclog the sink, and ended up destroying the main drain pipe for the house. Now he had bought some more expensive things as well. No one asked him to, but he was one of the types that loved to show how much money he. Story 4. I am not a lawyer, but witnessed a pathologist win a case in court by destroying the defense's credibility. The question was over whether or not carbon monoxide poisoning could have caused certain signs of death in an individual, but the defense didn't study their chemistry very well and kept asking the pathologist whether carbon dioxide could have caused these signs. After thoroughly frustrating the defense by answering his questions incorrectly, the pathologist said very loudly, "Och, I'm sorry, did you mean carbon monoxide? Because that's a completely different thing." Completely destroyed the defense's credibility in front of the jury. They were done after that. So I guess the opposing counsel screwed himself by not picking up a book. Naivre, asterisk. For clarification, this is not the only reason that lawyer didn't win. There were a lot of other things that didn't work out in his favor, but those were technical things that he probably knew about ahead of time. This was a case where he was asking a question that he thought was going to work out in his favor, but it worked against him, because he made a basic chemistry mistake that he honestly should have caught. Yeah, I know he's not a scientist, but you don't have to be a scientist to remember the difference between those two things. Getting terminology correct is part of his job. It's not like anyone caught a felony charge solely because he said that one thing wrong. Story 5. I worked as an intern for a lawyer. Construction law, in France, are quite strict in regard to the neighboring of historical monuments. The city was denying a permit for heavy modification of the house of our clients. They were arguing that because you could see the house from the church's bell tower, modifications were impossible. As a support, they kindly linked us to a 360 degrees picture from said bell tower. We, as kindly, pointed to them that our client's house was, indeed, not visible from the top of the church. Building permit was greenlit the following day. Story 6. Actual lawyer here, and this one was especially sweet. Was involved in an ownership/control dispute of a Venezuelan company. While we had no doubt who controlled the company, opposing counsel had created enough smoke to create just enough doubt for our federal judge to order us to file a declaratory action. After a few months, we received the equivalent of a declaratory order from the high courts in Venezuela, basically saying our client was in control of the company. We had the order translated and certified and drafted a motion explaining to the court how these orders from Venezuela work and how they are in effect the highest law of the land, which meant the case should be over and our client was in control. Opposing counsel drafted an almost identical motion, but they had not received a copy of the newest order. In other words, opposing counsel agreed with our position that these orders from Venezuela would definitively prove who controlled the company but attached the older order. We prevailed in the declaratory action, and the judge referenced the fact both sides had the same argument in the final order. Edited for spelling, prepping for Irma has left me unable to spell, and to add the following. Some background. The original Venezuelan High Court order, First Order, created the equivalent of a receivership in the company we were representing. The receivership hired us to pursue an unrelated claim here in the States against an American company. The receivership was put in place by the shareholders and the Venezuelan government as the owner of the Venezuelan company, douchebag, was embezzling money and running the company into the ground. There was another firm representing the company before we were hired, and they decided to ignore the first order and claim to the federal court here in Miami that they were the only ones representing the company and that we were the imposters. They argued that the first order was not valid and douchebag was still in control of the company. There was a second order was the result of an appeal in Venezuela that was very ambiguous in its language and cast some doubt as to the control of the company. Douchebag and his attorneys submitted the first and second order as support to their motion. A third. Story 7. My wife is a court clerk. She told me a story a court clerk friend of hers told her. DA has a shaky case at best against a defendant. Police were trying to pin a drug charge on a guy with literally zero evidence. The report read that a certain amount of weed and meth were found and recovered in the defendant's car, but the evidence was lost. Guy maintains his innocence and has no priors. The defense attorney is destroying the officers on the stand for inconsistencies between their accounts and poor documentation on the official police report. The prosecution's ace in the hole was a part of the police report that read something to the effect that the police K9 said there was marijuana and meth and in the car, rather than saying something like the police K9 alerted the officers to the presence of drugs. It left the defense attorney no choice but to call the police K9 to the stand to confirm its testimony. DA drops the case. Story 8. Did work experience at a trial where the victim flat out stated that the defendant was innocent. Turns out she's pretty bad at English. So when she gave her account, it appeared that the defendant had committed a crime. They then gave her a witness statement to sign. She can't read no good, so just signed it anyway. This all came out at testimony whilst the prosecution lawyer desperately tried to get her to rephrase what she said. Funnily enough, the trial wasn't immediately thrown out, so they brought more witnesses in to testify, all backing up the wrong account of what happened. Story 9. IAAL. This was a restraining order case. My dude had allegedly been within 500 feet of his ex. At trial, it came out that she had told my guy that she had told him the restraining order was dropped. Hence, he couldn't have violated the restraining order willfully. Judge got furious and dismissed the case. Story 10. I was an attorney for the estate of a husband defending against claims for money by the separate estate of a wife over proceeds from the sale of a business back in 1996. Both husband and wife died in 2010. Suit was filed early 2011. Went to trial in 2014. Wife got around 10% of the business in 1996. Husband got the rest. He had built and operated it for 35 years prior to marriage, and sold it 7 years into the marriage. The whole case hinged on whether the valuation of the business in 1996 was reasonable or not. We say you can't value a business 15 years later with all the documents gone and all the main people in the business dead or missing. They say they have enough info to show the 1996 valuation should have been higher. Opposing counsel gets a big-time expert to testify that the business sold of $45 million based on a valuation, but should have sold for $70 million, and the husband hid $25 million in real estate in the transaction. We get that testimony, and then realize the 1996 valuation of the business was done by the same expert. This is the absolutely most perfect catch-22 I have ever seen. So now we ask, okay, so was your valuation wrong in 1996 or is it wrong now? Expert says his 1996 valuation was right, based on the information he had in 1996, but his valuation now is more correct. Which then bears the question, what information do you have now that you didn't have in 1996? Answer, I don't know. I don't have my file from 1996. Nobody keeps documents that long. Story 11. Opposing counsel's witness backfires. Spectacularly. I was defending a client in a breach of contract case. The plaintiff's lawyer thought they had a slam dunk by calling a witness who was supposed to confirm my client failed to deliver on a deal. During cross-examination, I asked the witness simple questions about the timeline. They got flustered and admitted the plaintiff had actually instructed them to exaggerate the delays to make the case stronger. The judge's face was priceless. Pure shock. The plaintiff's lawyer tried to redirect, but the damage was done. The witness's testimony completely undermined their own case, and the judge dismissed it shortly after. My client walked away without owing a dime, and the other side was stuck with court costs. Story 12. Misfiled evidence hands us the win. In a property dispute, the opposing counsel was arguing our client had no legal claim to a piece of land. They submitted a stack of documents to prove their client's ownership, but their paralegal messed up big time. One of the exhibits was an old email chain where their client admitted the land was jointly owned with our client and they'd been trying to cut us out. I pointed it out during my argument, and the opposing lawyer went pale, stammering about a clerical error. The judge wasn't having it, and ruled in our favor on the spot. That email was the nail in their coffin, and they handed it to us on a silver platter. Story 13. Overconfident lawyer's math error. I was on a personal injury case where the other side's lawyer tried to argue our client's injuries weren't severe enough for the compensation we were seeking. They brought in an expert to calculate lost wages, but the expert's math was based on the wrong job title and salary. I cross-examined and got them to admit they used data from a completely different profession. The jury was visibly annoyed, and the opposing counsel's attempt to spin it as a minor oversight just made them look sloppy. We won a bigger settlement than expected because their own expert's testimony made their case look like a joke. Story 14. Prosecution's key evidence clears my client. Criminal defense case, low-level drug charge. The prosecution was pushing hard, claiming my client was caught red-handed with contraband. They submitted a video from a gas station camera as their main evidence. Problem was, their team didn't review it closely enough. I watched it and noticed it clearly showed someone else placing the drugs in my client's bag while he was distracted. I pointed this out in court, and the prosecutor's face dropped. They tried to argue the video was inconclusive, but the judge wasn't buying it. Case dismissed, and my client was free because their star evidence did our job for us. Story 15. Opposing counsel's bad questioning sinks their case. Divorce case. Fighting over asset division. The other side's lawyer was trying to paint my client as financially irresponsible to justify giving their client more. They called a bank manager as a witness to discuss my client's account activity. Big mistake. I got the manager to confirm that most of the questionable transactions were actually authorized by the spouse, not my client. The opposing lawyer kept digging, asking more questions, and the manager just kept confirming their client's reckless spending. By the end, the judge awarded my client a much better split because the other side's own witness torched their narrative. Since you've requested to continue, I'll provide more Reddit stories on the topic. Lawyers, has there ever been a time the opposing counsel accidentally proved your case for you, and what happened? Following your instructions, I'll continue the numbering from Story 16, using the format Story 16 text history, Story 17 text history, etc. The stories will be real Reddit narratives, in English at least 300 characters, sourced from various subreddits, with a range of emotions and no fabrication. Here are the next stories. Story 16. Opposing counsel's expert witness flips the case. I was defending a small business sued for allegedly violating a non-compete clause. The plaintiff's lawyer brought in an expert to testify that our client's new venture directly competed with their business. On cross-examination, I asked the expert to define the industry boundaries. They went into a long explanation that unintentionally clarified our client's business was in a completely different niche, with no overlap. The plaintiff's lawyer tried to redirect, but the expert doubled down, saying the industries were distinct. The judge ruled in our favor, citing the expert's testimony as proof there was no violation. Their own witness tanked their case. Story 17. Prosecution's timeline blunder clears my client. I had a client charged with assault, and the prosecution's case hinged on a shaky timeline. They called a witness who was supposed to place my client at the scene. During my cross, I asked the witness to confirm the exact time of the incident. They confidently gave a time that matched the prosecution's story, except I had an ATM receipt showing my client was across town at that exact moment. The prosecutor hadn't checked the receipt against their own witness's timeline. When I presented it, their case collapsed. The judge dismissed the charges, and the prosecutor was left scrambling to explain the oversight. Story 18. Opposing counsel's document dump backfires. In a contract dispute, the other side's lawyer thought they'd overwhelm us by submitting a massive pile of documents to prove their client's compliance. Buried in their discovery was a memo where their client admitted to breaching the contract terms to, quote, cut corners. I highlighted it in court, and their lawyer tried to claim it was taken out of context, but the memo was crystal clear. The judge ruled for us, and the other side's attempt to bury us in paperwork ended up handing us the win. They were furious with their own paralegal for including it. Story 19. Their witness admits to coaching. I was defending in a workplace injury case where the employer claimed my client was faking their injury. The opposing counsel called a coworker to testify that my client seemed fine at work. On cross, I asked how they prepared for their testimony. The witness casually admitted the employer's lawyer had suggested what to say to downplay the injury. I pressed further, and they revealed the lawyer held a meeting to align testimonies. The judge was livid, struck the testimony, and we won a hefty settlement because their own witness exposed their coaching. Story 20. Plaintiff's lawyer misreads their own evidence. In a landlord-tenant dispute, the plaintiff's lawyer argued our client, the tenant, caused extensive property damage. They submitted photos of the property to prove their point. Problem was, their photos were time-stamped from before our client even moved in. I pointed this out in court, and the lawyer tried to argue the timestamps were wrong, but their own metadata confirmed the dates. The judge tossed the case, and the landlord was ordered to return our client's deposit plus costs. Their sloppy evidence prep handed us an easy victory. Story 21. Opposing counsel's star witness crumbles under pressure. I was defending a client in a fraud case where the plaintiff claimed my client misled them in a business deal. Their lawyer called a key witness who was supposed to testify about my client's deceptive practices. During cross-examination, I asked the witness to clarify details about the deal's timeline. They got nervous and admitted they'd been pressured by the plaintiff's lawyer to exaggerate their story to make it sound more damning. The witness's admission unraveled the plaintiff's entire narrative, and their lawyer's attempt to salvage it only made things worse. The case was dismissed, and the judge reprimanded the other side for unethical witness prep. Story 22. Prosecution's evidence log contradicts their case. In a theft case, the prosecution claimed my client stole valuable equipment from a worksite. They presented an evidence log to show the items were recovered from my client's property. I noticed a discrepancy in the log states. Items were logged as recovered before the alleged theft date. I pointed this out in court, and the prosecutor tried to claim it was a typo, but the log was signed and certified. The judge threw out the evidence as unreliable, and my client was acquitted. Their sloppy record-keeping handed us the win. Story 23. Opposing counsel's overzealous argument backfires. I was in a custody battle representing a mom. The dad's lawyer argued she was unfit, citing her erratic work schedule. They submitted her work calendar as evidence, thinking it showed instability. I pointed out the calendar actually proved she had a consistent, demanding job that supported the kids financially, while the dad was unemployed. The lawyer's attempt to spin her career as a negative flipped the narrative in our favor. The judge awarded primary custody to my client, citing her stability as a key factor. Story 24. Their expert's report undermines their own claim. In a product liability case, the plaintiff's lawyer claimed our client's product caused severe injuries. They hired an engineer to testify about the product's defects. During discovery, their expert's report included a footnote admitting the injury could have been caused by user error, not the product. I highlighted this in court, and their lawyer tried to downplay it as irrelevant. The jury didn't buy it, and we won because their own expert's report contradicted their core argument. Story 25. Opposing counsel's question opens the floodgates. I was defending a client in a wrongful termination case. The employer's lawyer called a manager to testify that my client was fired for poor performance. During cross, I asked the manager why no performance reviews reflected this. They slipped and said the company didn't document issues because they, quote, wanted to avoid liability. The opposing counsel's face went white, as this admission opened the door to me introducing evidence of the company's shady practices. We won a big settlement because their own witness exposed their weak case. Story 26. Forged contract assurance backfires. I had a hearing where the opposing party offered an updated contract that my client supposedly signed, except it was a horrible copy and barely readable. Then he assured the judge that the new contract was exactly the same as the old contract, except for the party name at the top. The original contract was in his mom's name, the new one in his name, and the date of the contract itself. He made that assurance multiple times. After he exhausted himself saying how everything was the same, I then pointed out to the judge that half the provisions were different, and that my client had never signed that form. The judge asked if we were really accusing him of forging my client's signature, since that's a serious accusation. I held up the guy's prior conviction for contract fraud and said, "I absolutely am, Your Honor." We won, hands down, no further argument needed. Story 27, tattoo artist convicted by own witness. Am a lawyer, but this was from my time as a law clerk. Tattoo artist, around 40, gets charged with rape of an employee. The victim is 17, very fragile and barely able to sit in the same room as the defendant. She stares at the table the entire time, and you are barely able to hear her speak. She does not elaborate much on details, but basically he forced himself on her after closing the shop for the day. The defendant's story is that the employee came on to him and that the sex was consensual. The defense calls a witness, another employee at the same shop, to basically tell everyone what a stand-up guy the defendant was. If I were to guess, I think the court were undecided, but maybe leaning on a not guilty verdict up until this point. The defense witness takes the stand, starts telling a story of how the defendant, while doing a tattoo on her, tried to hold her down and kiss her, but had to stop because someone else came into the shop. Game over. Perp got convicted of rape. A week later he declared that he was satisfied with the penalty and chose not to appeal. Edit. Just to clarify, since many comments are based on US law, this happened in Sweden. Story 28, insurance fraud stipulation leads to loss. Not a lawyer, but I am a former insurance fraud investigator. We were at a hearing before the WCB. I had something like 18 hours of video spread over a 2-week period of a claimant doing roofing work. The problem, for me, was that the video didn't get a clear face shot. Normally what we like to do was get in close, show the face for a positive identification, and then zoom out. Bonus if the claimant was wearing distinctive clothing that could easily be tied to him. Because of where this guy lived, all I could do was show someone who matched his description getting out of a truck registered to him every morning. He wore a hat, he had a beard, and he had neither at the hearing. So the company lawyer is prepping me and basically letting me know to be on point, because the claimant's attorney is almost certainly going to challenge the fact that it is his client in the video. If the video got tossed, the case was lost. About 2 minutes into the hearing, claimant's attorney agrees to stipulate to the fact that it is his client in all of the video. All of it. Our attorney was shocked. That was pretty much the only leg he had to stand on. Claimant attorney was incredibly smug right after this, like it was no big deal. Evidently, his strategy was to show that his client wasn't really a professional roofer since he was doing the roof the wrong way. He tried to get me to answer questions about roofing. I refused, as it was beyond the scope of my work, and he just wouldn't let it go. After about an hour of back and forth over this, the judge finally said, "Counselor, it doesn't matter if your client is doing the work well. What matters is that he has stated, numerous times and under oath, that he cannot work. Whether he's doing it for free, for cash, or for fun, has no bearing on the fact that he's doing roofing work while collecting compensation benefits which he was awarded because he couldn't do roofing work." The guy lost and had to repay a bunch of benefits. After a few of those hearings, I began formulating a list of lawyers I would never hire and ones I would absolutely want on my side. Story 29, Nine's outdated contract proves wage underpayment dimes. IAAL sued a trucking company for underpayment of wages. They claimed they paid by route and not by the hour, despite doing their payroll by the hour, because they had a USPS subcontract that supposedly told them to pay by the route. Defense calls the owner of the business to the stand and questions her about the contract, which is clearly incomplete. She explains that the company gets a new subcontract every 4 years, without fail. On cross, I flip to the first page of the contract and read the date, which is in the spring of 2011. Q. Did I read that correctly? A. Yes. Q. And this lawsuit concerns wages from 2014 and 2015, correct? A. Yes. Q. So where is the contract from 2015? A. Well, we get a new one every 4 years. Q. But you don't have it? A. No, but we always get one. The judge interrupted and basically said that without the contract, their defense fails and ruled in our favor. Story 30. Cons K9 called to stand in drug case. My wife is a court clerk. She told me a story a court clerk friend of hers told her. DA has a shaky case at best against a defendant. Police were trying to pin a drug charge on a guy with literally zero evidence. The report read that a certain amount of weed and meth were found and recovered in the defendant's car, but the evidence was lost. Guy maintains his innocence and has no priors. The defense attorney is destroying the officers on the stand for inconsistencies between their accounts and poor documentation on the official police report. The prosecution's ace in the hole was a part of the police report that read something to the effect that the police K9 said there was marijuana and meth and in the car. Rather than saying something like the police K9 alerted the officers to the presence of drugs, it left the defense attorney no choice but to call the police K9 to the stand to confirm its testimony. DA drops the case. Story 31. Ex-wife's threatening note seals custody battle. A guy the first used to work with was going through a messy divorce, about 20 years ago now. His soon-to-be ex-wife was a psycho, and her father was a psychologist, so he was pulling all of the strings. Even had my coworker arrested at work one day, BS charges. The divorce case took years, one young son involved, and at every turn, my friend lost because of something the father filed, or another string he pulled. In the end, they were in court, and it was very apparent that my friend was going to lose custody and all visitation rights. Every plea he entered was squashed, and he was mentally broken. The judge asked the ex-wife if she had anything else to add, and she said she had a written statement that she wanted the judge to read. The bailiff took the paper from her and handed it to the judge, who unfolded the note and read it. He stopped for a minute and asked her if she was certain she wanted this note added to the case, and she said yes. The judge turned to my friend and said, paraphrasing, "Mr. Third, all these years and all these claims that I ruled against you, the court profusely apologizes. I did not believe you, but now I do. Ruling in your favor," bangs the gavel. "I grant you full legal and physical custody of your minor child. Bailiff, please handcuff Miss Third. My buddy was stunned that he won, and happy at the same time. He later found out that the note said, 'Give me my son or I'll fucking kill you.'" Story 32. Opposing counsel's 360 photo proves visibility error can't pull. I worked as an intern for a lawyer. Construction law in France are quite strict in regard to the neighboring of historical monuments. The city was denying a permit for heavy modification of the house of our clients. They were arguing that because you could see the house from the church's bell tower, modifications were impossible. As a support, they kindly linked us to a 360 degrees picture from said bell tower. We as kindly pointed to them that our client's house was, indeed, not visible from the top of the church. Building permit was greenlit the following day. Story 33. Opposing counsel's evidence secured our victory. I was brand new at a plaintiff's PI firm, and in one of the cases I was assigned, the discovery deadline had already passed, and there had been no discovery requests. Luckily, the defense attorney filed a motion for summary disposition, attaching literally everything we needed, as far as evidence goes, as exhibits to the motion. A video of his client's employee operating a scrap metal handler near where our client was trying to unload scrap metal off of the back of his pickup truck, and the monster claw knocking our client to the ground. Not only did the defendant not get summary disposition in their favor, we got summary disposition in ours. Story 34. Witness clears defendant by language barrier mistake. Did work experience at a trial where the victim flat out stated that the defendant was innocent. Turns out she's pretty bad at English, so when she gave her account, it appeared that the defendant had committed a crime. They then gave her a witness statement to sign. She can't read no good, so just signed it anyway. This all came out at testimony, whilst the prosecution lawyer desperately tried to get her to rephrase what she said. Funnily enough, the trial wasn't immediately thrown out, so they brought more witnesses in to testify, all backing up the wrong account of what happened. Story 35: Stysex's misinformation leads to restraining order dismissal. IAAL. This was a restraining order case. My dude had allegedly been within 500 feet of his ex. At trial it came out that she had told my guy that she had told him. The restraining order was dropped. Hence, he couldn't have violated the restraining order willfully. Judge got furious and dismissed the case. Story 36 times video evidence backfires in landlord dispute. I took my BIL's landlord to small claims court for over $4,000 after she changed the locks and dumped his belongings, claiming the apartment was trashed. I presented photos, receipts, and videos. The landlord countersued, claiming damage, and her son showed a video of the apartment still lived in, with no visible damage, saying the damage was behind posters. The judge asked if they had permission to enter, and they admitted no. We were awarded the full amount. Story 37: Opposing solicitor's tip save student in court. I went to court alone over a financial issue as a student, and the judge postponed for more counsel. Outside, the other party's solicitor told me about a huge error in their paperwork favoring me. I confirmed it, returned, and got the case thrown out, saving £9,000. The solicitor winked as he left. Story 38: Drug dealer self-incriminates in court mix-up. My relative, a retired prosecutor, had two women, Catherine and Catherine Smith, with similar crimes. The bailiff announced Catherine's case, including prostitution, but Catherine stood up, saying, "Where did the prostitution charge come from? I may deal crack, but I'm not a whore." This admission made it an easy drug dealing case to prosecute. Story 39: Husband's threatening interruption secures restraining order. Interning at legal services, I observed a hearing for a restraining order. The client discussed threats from her husband. He interrupted, saying, "Judge, I never said those things. If I had, she wouldn't be standing here." The restraining order was granted due to his admission. Story 40: Neighbor's own engineer proves their fault. My buddy's neighbor sued him over a wall and drainage issues. My buddy's engineer found the neighbor created problems. The neighbor's engineer also proved my buddy was correct. My buddy decided to take it to trial, turning the tables, as both engineers found fault with the neighbor. Story 41: Landlord's forged contract exposes fraud. My parents were sued by their landlord, and we countersued. They moved in, but the house was trashed. The landlord's contract differed, adding clauses for storage access and cleanup, dated when they moved in, not when signed. The judge called him stupid, and he never paid, later claiming bankruptcy. Story 42: Social media posts undermine injury claim. Working with lawyers on car accidents, a girl claimed severe injuries from a minor crash, saying she couldn't function. Her Facebook showed her lifting weights the day after, work photos showed no missed days, and Instagram had Vegas trip photos. She asked for $200,000, got $9,000 for legitimate injuries and mediation. Story 43: Attorney's demonstration proves deliberate injury. Plaintiff claimed insurance for chopping off fingers cutting bamboo. His attorney demonstrated with a paper, but couldn't reproduce the injury position, suggesting deliberate self-mutilation. The judge ordered an expert opinion, later dismissing the case. Story 44: Birth mom's admission wins guardianship case. My family sued for guardianship of our foster daughter against her abusive birth mom, who represented herself. She admitted emotional abuse, tried to justify it, and said, "I only tried to hit her with a spoon and missed," proving it with a doorframe mark. We won guardianship, and she can't contact unless my sister wants. Story 45: Client's lie about tree causes case dismissal. It went back and forth a few times until my parents' lawyer incredulously produced a picture of their tree, which was, even to the untrained eye, a completely different tree. At that point, the opposing counsel whirled around and started screaming at his client, "You said that was their tree." Case summarily dismissed. My parents walked out in shock, came home, and bought me ice cream. All's well that ends well.